Someone you love has passed away, and in the will, right there in black and white, it says you're the one in charge. So you go to the bank to close out an account, or you try to sell the house, and the bank says no, and the title company says no, and nobody will talk to you. Here's the thing almost nobody expects in this situation. Being named in a will does not automatically give you legal authority to act. Not the day someone dies, not the day you find the will, not even the day you read it out loud to the family. So what actually gives you the power to step in? That's what I want to walk you through. This video, though, is just for educational purposes. It isn't legal advice because every estate is different and the details of your situation matter. But let's talk about how generally this works. Here's the first thing that can trip people up. There isn't just one answer. What gives you authority depends on one key detail, whether the person set things up with a will or with a trust. Those two paths look almost nothing alike. And there's a second surprise waiting for a lot of people. Even with a will naming you by name, you may still have to ask a judge for permission to act with authority. Let's start with why that is. When someone dies with a will, the person named to handle everything is called the personal representative, or you might hear executor. But naming someone in a will is really more like a nomination. It tells the court who the deceased person wanted in charge, but is not by itself legal authority. To actually get that authority, the nominated person typically has to go to the probate court, file a petition, and ask the judge to formally appoint them. And once that happens, the court issues a document, usually called letters testamentary, and that piece of paper is what the banks, title companies, and other institutions usually want to see. If there's no will at all, someone still has to be appointed, and it's usually just called administrator instead of executor, and the court follows a priority list, usually starting with a spouse or adult children to decide who that should be. Here's where the second path comes in, and it's generally different, a trust. If someone set up a revocable living trust and moved their assets into it before they died, the person named as successor trustee doesn't need a judge's permission at all. The trust document itself is the legal authority. Typically, all the trustee needs is a death certificate and the trust paperwork to start managing and distributing things for the estate. For example, take Sarah. Her dad named her executor in his will. She assumed that meant she could start handling things immediately after he passed, pay his bills, access his accounts. But every institution she called asked for letters testamentary. She had to file a petition with the probate court first, wait for a hearing, and only after a judge signed off did she get that document, and only then could she actually act. Her cousin, in a similar situation the year before, was named successor trustee of his mother's trust. He walked into the bank with a death certificate and a trust document, and within days he was managing the accounts. No judge, no waiting on a hearing. So they had the same goal, getting authority over someone's affairs after death to take care of things, but two different roads to get there. So to directly answer the question, how do you actually get authority over an estate after someone dies? Well, if there's a will or no will at all, you generally need to petition the probate court to be formally appointed as personal representative or administrator. Once appointed, the court gives you letters testamentary or letters of administration, and that's your legal authority. But if there's a trust and the person's assets were properly funded into it, the named successor trustee typically steps into that role using the trust document and a death certificate without needing a court appointment at all. Which path applies to you and your situation depends entirely on how the person's estate was set up. That's exactly the kind of detail where the facts matter. Whether there's a valid will, whether a trust exists and was properly funded, what state you're in, whether there are disputes among family members, all of that can change the process. This is general information, not a roadmap for your specific situation. Only an attorney who's looked at the actual documents can tell you where you stand. I know this can feel overwhelming on top of everything else you're carrying right now. You don't have to figure it all out alone. If you'd like to understand how the law may apply in your situation, the attorneys at Woodbury and Ybarra offer a free consultation when you mention this video. The phone number and website are in the description below. They can help you understand how to move forward and what next steps you need to take.